The court will next hear the case of Barbara McKenzie versus Mental Health Care, Inc. and Summit Claim Center.
Yes, please, Lord. Thank you, Your Honor. Good morning. My name is Mike Weiner. I represent Barbara McKenzie, and I'd like to, at the outset, reserve 2.5 minutes for rebuttal, please. And thank the court for the opportunity for having to be heard today. Ms. McKenzie's listening via the World Wide Web, hopefully, and she was not able to be here. This is a workers' compensation case involving a traumatic physical assault that occurred in the workplace. And I want to begin by illustrating to the court and highlighting that this is not an outlier case. This is not sort of that one in a million, but rather this is a case that, from our perspective, is not an uncommon one. I've had, in the course of my practice, at least probably, I would say, a half a dozen cases.
Can I ask you, under what statutory provision are you saying that your client should be able to receive the psychiatric treatment that she's seeking? Is that 440.091 or is that 440.093.2?
Well, under 440, I think it's governed, Your Honor, under 440.093.
0931 or 0932?
2.
So 0932 refers only to manifestations. Would you say that's fair?
Well, it refers to manifestations in the first sentence, and then it goes on to say that the compensable injury must be the major contributing cause, a compensable physical injury, again, a term not defined by statute, but must be the major contributing cause of the psychiatric disorder.
So if we go to 440.09, where we find coverage, it talks about manifestations, and the way it talks about manifestations are that manifestations flow from the injury, correct? Just like the disability might flow from the injury, the manifestation flows from the injury.
Correct.
So in order to recover for your client under 2, you have to be able to show that, in fact, this psychiatric injury that she has is the consequence of the injury that she received, the workplace injury.
That's what the statutory language says, and one of the errors that we complain of that the lower court committed was that it so narrowly construed the injury. In this case, you really can't distinguish the attack from the physical injury. The physical injury in itself is the attack.
Well, I mean, 440.0931, at least the way I read it, and obviously I can't speak for my colleagues, but it really talks about 3 kinds of mental or nervous injuries. Those which are caused perhaps just by observing something horrific at work. I mean, you see someone get killed or something and you suffer real psychological harm, the statute says we're not going to compensate that, even though we recognize that that's probably real, right?
Correct. And I think 440.091 just sort of sets forth the criteria for excluding mental injuries. And
so you would not, because I thought it set forth these 3 different kinds of mental injuries, 2 of which we're going to say are not compensable, and 1 of which we are going to say is compensable, and that's the one where you have a physical injury and you also, at the same time, suffer a psychological injury. And it just seemed to me, going through this case, that would be your client's situation, is that she would, any claim that she would have to be brought under, at least from the testimony that was presented, because when the judge says that there was no testimony that this is a manifestation, really looking at what the doc said, it really wasn't a manifestation as flowing from the injury. It may have obviously had its genesis in the accident, but the accident is different from the injury, correct?
Well, and again, I would respectfully disagree with the court on that point. We believe that the accident itself is indistinguishable from the physical injury because of the circumstances under which it arose. And to interpret the statute in a manner in which the lower court does leads to an absurd conclusion, and particularly with respect to these post-traumatic stress disorder cases. In the cases that I've seen in the past and that are sort of analogous to this case is if you've got an injured worker who suffered a gunshot wound, for instance, in a bank robbery. I've had another case in the past where I've had an injured worker who was working as a convenience store clerk and came in and was stabbed and held at knife point. Well, those physical injuries heal, and sometimes they can heal relatively quickly. But the manifestations of those physical injuries can last for a lifetime.
But you don't have any testimony that talks about this being a manifestation of the injury. All your docs, in the best case scenario, say that it's a combination of all her life issues combined with the accident itself, combined with the injury. and no one said this injury, for instance, perhaps you suffered a grotesque burn and the pain is now causing psychological problems, and the doctor says because of this pain they're suffering psychological. I mean, because the statute clearly in Paren 2 compensates those kinds of psychological injuries or provides treatment for those kinds of psychological injuries if the medical testimony is there that it flowed, this need for psychological treatment flowed from the injury, and you don't have that here.
Well, I would respectfully disagree. I would direct the court to the deposition testimony of Dr. Hussein, who agreed that the industrial accident and the physical injuries from it were the major contributing cause of the disability and need for psychiatric care. And then Dr. Foreman, whose testimony in a certain sense is all over the place, but in the final analysis he identifies 3 causes for her post-traumatic stress disorder, one of which was the laryngeal contusion, the other one which was the compensable physical assault, which again we label as an injury, and then the other one was the fear of her perpetrator. So interpreting the evidence in that light, we would submit that it was unanimous and it was uncontroverted that the evidence supported that burden of proof under subparagraph 2.
But if we read number 2 and it has to be a manifestation, it has to flow, and there has to be medical testimony, then it would be reasonable for the JCC to say, look, your doc said 3. I can't find major contributing cause flowing from the injury when she talks about these other events also.
Well, again, turning back to Dr. Foreman's testimony, he identifies 3 causes, 2 of which are reasonably attributable to her physical injuries, the laryngeal contusion and the loss of her voice, as well as the physical assault itself.
I guess, Mr. Warner, what I'm really asking is number 1, I think that there is a cause where you suffer a mental or nervous injury at the same time as you suffer your physical injury, and one makes provision for that as long as your physical injury requires medical treatment. Then you can also receive treatment for your psychological injury. And so there are really 4 types of mental or nervous injuries that the statute refers to. 2 of them the statute says they will not be compensable. 2 of them the statute says will, and of those 2, you've attempted to prove your case under a manifestation where the JCC found that she was not persuaded that it was a manifestation, and it just seems to me that there's competent substantial evidence to support that conclusion, but not that but your client perhaps should have gone under number 1.
Well, again, we would, understanding the court's interpretation of number 1, it would be our position that she would have met the burden of proof under number 1 as well.
Well, she may have, but that wasn't really presented to the JCC, was it?
Well, the entire issue that was presented to the JCC was one of compensability under 440.093. So in a broad context, yes, absolutely it was.
But I mean, how far does the JCC go on those kinds of situations? In other words, you're saying, Judge, this is a manifestation, this is a manifestation. The EC is saying, no, it's not, no, it's not. And so the judge basically rules on the issue brought before her.
Well, yeah, and Your Honor, and the issue before the judge was compensability of the psychiatric condition under Section 440.093. So, the court would have erred with respect to its misapplication of subsection 1, as Your Honor has identified, just as it would have erred according to our interpretation of the evidence by misapplying the law with respect to subsection 2.
I'm sorry, I've consumed a lot of your time. You are in your rebuttal time. I don't know.
Good morning, Your Honors. May it please the Court. My name is Ben Crystal. I represent Mental Health Care as well as Summit Claims Center, which are the appellees in this matter. Your Honor, one of the things I think that was touched on this morning in oral argument is that there seems to be a misapprehension on the part of the appellant in sort of combining the word accident and injury and then bring the court to the conclusion that it's really the same thing, and therefore all of the doctors who were relating the mental condition to the actual attack or incident itself are really saying it's the same as relating it to the physical injuries, and that couldn't be any further from the reality of the definition of both accident as well as injury. In fact, both terms are clearly defined in the statute itself. They've been there since the 1940s. Accident is clearly defined in Section 440.02 sub 1. And incidentally, up until the 2003 law changes, it included the exemption that what an accident cannot be is a mental or nervous condition caused by stress excitement alone. That's been moved to Section 440.093, which is now the psychiatric compensability section of the statute.
So under that, if in the situation here there had been an attack, but the attacker swung and missed, no physical injury, no ability to recover, even though you may have a mental issue, but where simultaneously with the attack there is a physical injury, why logically doesn't the mental condition flow from that? And isn't that what the doctors are saying?
Actually, no. I think what the doctors are saying is that the psychiatric component of her injuries is related to the attack itself. In fact, when Dr. Foreman discusses the DSM-IV and of post-traumatic stress disorder, the emphasis on post-traumatic stress disorder is the fear or threat of the physical injury. It's not the injury itself that causes the disorder.
But it's the physical injury. His testimony is really clear that her mental condition is the fear, in part, caused about the fear of the physical injury, not just the attack, if there was no physical injury. That's the attack. The attack is this person attacking her. She happened to get a physical injury. And it seems to me the testimony is clear that it's a fear of a physical injury. And so that relates it to the physical injury, doesn't it?
Well, I don't think so. And I think, Your Honor, by posing it that she happened to also get a physical injury is really the point of what the legislature was writing about when they drafted this type of language, that the physical injury can't be incidental to the mental disorder that's created by this threat or the attack or the accident itself. It's got to be the injury that is the actual cause of the medical condition.
And your argument is they didn't meet their burden of proof, as the JCC found, because they needed an expert witness to say this throat injury generated depression, anxiety, and it is true that some of this testimony is difficult to follow at times, but that just wasn't met here. You can have that in a case where a physical injury, for example, a worker is paralyzed, right, and they then develop depression, and a doctor could easily testify that paralysis created a depressive disorder.
Sure, and that happens on a regular basis, and benefits are provided for those types of...
I mean, this claimant wouldn't necessarily be told... I mean, what Judge Van Noordhoek was outlining would be compensable if it was sought correctly, wouldn't it? I mean, in other words, I can suffer a physical injury that requires medical treatment. Once I do that, under number one, I am eligible now to receive any treatment that I may need for a psychological injury incurred at the same time. I mean, we can have psychological injuries. There's nothing about the statute that says there's no such thing as a psychological injury. The statute recognizes that psychological injuries occur, and they can be accidental, and they can have occupational causation. I mean, everything about them, except they're a mental or nervous injury versus a physical injury, and we're just not going to compensate them unless they occur at the same time as a physical injury that requires medical treatment occurs, or unless it's a manifestation. Here, it was argued that this was a manifestation, and all these doctors talked about life situations and children and marriages and fear of the individual and the actual injury itself. But the manifestation has to flow from the injury, so clearly it's not number two if the statute means what it says, but it could have been number one, couldn't it?
I don't believe so, because I think the point is, I don't believe that the statute says that if you develop a mental injury, the timing of it determines whether or not it's compensable, and that it happens at the same time that the physical injury happens. I don't believe that the statute says that.
The statute recognizes that you can be psychologically injured from an accident, correct? I mean, if someone walks into the convenience store where you're a clerk and starts shooting a gun up in the ceiling, and you are placed in fear from that, I mean, that you could really suffer a psychological injury. It's just the statute says we're not going to compensate you, right?
I agree with that, yes.
Now let's say that, you know, he shoots at the ceiling and then he takes the gun and whacks you on the side of the head with it. Now you have a physical injury and you have a psychological injury that occurred at the same time. That would be compensable, that psychological injury under that hypothetical, wouldn't it?
No, I believe there still has to be a causal nexus. I don't think you can read, I don't think subsection 1 of 44009 is one method for proving compensability, and then subsection 2 is a separate method. I think there still has to be that causal
So you disagree
nexus.
with my interpretation of the statute, that 1 are the mental or nervous injuries that occur at the time of the physical injury or at the time of the accident, and 2 are those which sometimes flow from a physical injury. I mean, the legislature is able to recognize that you could, in fact, suffer a psychological injury at work, and also recognize that sometimes the injuries that you suffer at work result in psychological injuries that need to be treated, and the legislature is saying under 2, we will treat that if it's a manifestation of the injury, not a whole and then number 1, the workplace psychological injury.
I believe that the statute compensates psychiatric or mental injuries, only those that flow from the injury itself. The compensable physical injury must be the cause of the mental or nervous condition.
It must be a manifestation.
I'm sorry?
Your argument is it must be a manifestation.
Correct. And that manifestation, the injury, the statute goes on to say that the compensable physical injury has to be at least 50% or greater of the cause of that psychological condition.
I mean, Paren 1 it basically has 3 sentences, and it's my interpretation from reading it at least that there would be 3 different types of mental or nervous injuries. So the second one is the one that I've been referring to, and so perhaps you can help me understand your point of view. Nothing in this section shall be construed to allow for the payment of benefits under this chapter for the mental or nervous injuries without an accompanying physical injury requiring medical treatment. So that looks to me like if I meet that last phrase in that sentence, accompanying physical injury requiring medical treatment, then in fact I can be recovered for my mental injuries as long as there's an industrial causation and stuff like that, which this woman, I think, would be able to show that there was an industrial causation or at least a triggering, or perhaps she might be able to show, I don't know, but I mean.
Well, I don't
but
believe.
that wasn't presented to the JCC.
That's true, but I also don't believe that section can be read without incorporating 44009(3). I think 44009(3) establishes the criteria.
That was 093. If you'll allow me to perhaps finish your sentence.
Sure.
I think your argument in listening to Judge Hawks as I was reading those 3 sentences and then subparagraph 2, you would read that essentially in paramateria to say that second sentence is saying the foundation for the mental injury must be a physical injury. It must be the physical injury must be 50% of the cause of the cycle of the overall of the compensable act. And then subparagraph 2 that says mental or physical injuries occurring as a manifestation shall be demonstrated by clear and convincing. So reading 093, the entire subsection together, it is a manifestation. It must be proven by clear and convincing evidence, and it must be based on the foundation of a physical injury.
Yes.
Well, a manifestation can only result from. I mean, if we read 440.09, it says manifestations resulting from injuries, and manifest, the word itself obviously suggests it's obvious. I mean, and clearly these situations that we're talking about are frequently things that occur perhaps months after the actual injury, where the total impact of the injury has finally come home to the claimant or been acknowledged by the claimant to the point where the claimant now needs psychological treatment.
I agree, but I still think that.
But you don't allow for any psychological injury at work. The horrific event that occurs, someone gets killed that you care about, or something. I mean, which clearly could. I mean, cause a psychological injury. The legislature says it could. They just say they're not going to compensate for it. They don't say it doesn't exist. They say we're not going to compensate for that injury.
Correct, and I believe that's been the law since 1941.
But what does the second sentence mean then? without an accompanying, I mean,
I think it just sets up the standard. I think subsection 2 essentially describes what the burden of proof is going to
well,
be.
manifestation is separate from an injury, right?
Correct.
I mean, you know.
Your argument is essentially, as I understand it, and it seems to be a fairly clear approach that's outlined in the statute, is I come back to the example of a paralyzed worker. A worker is paralyzed by a fall. That psychological injury, it may not manifest for a year. They go through rehab. They're dealing with the physical ramifications of the injury. They're just trying to cope with that physical, traumatic, or catastrophic event in their life. Then they begin to notice that they're depressed. They then come back in and file a claim and say, my depression manifested from the paralysis. That is essentially what the legislature has described as a compensable psychological injury.
And that's the scenario that they believe to be, or that they have written to be compensable.
And under your scenario, there's no other psychological injury that's going to be compensable except the manifestation.
A manifestation from a physical injury. I believe that's how the legislature has written it. I believe that's how they've had it in there since the work comp statute was originally enacted.
So you don't see any pleading problem here. You see some. I'm sorry, may I continue this time?
Yes.
You don't see any pleading problem here on behalf of the claimant. You simply see that this is a case where the psychological injury does not flow from the tear in the throat.
Correct.
I'm sorry, I know you're over, but Mr. Weiner in his brief mentions a case of rape where there could be very little physical injury. I mean, Judge Thomas is talking about being in a wheelchair for the rest of your life, and the physical injury from the traumatic event of sexual battery might be healed in a week. The physical injury's gone, but the mental injury is significant. It may not ever be gone. I mean, but you're saying that's not a separate injury that occurs at the same time. You're saying that would have to be a manifestation of perhaps a small tear or a bruise. And no one would testify that was the case, I would think.
Well, I believe you're referring to the Byrd case. And in the Byrd case, they made a special exception for rape, and they went through some very specific criteria of how not only is it the state's interest to hold the situation of rape more serious than any other work situation, but it's also the federal government's interest, and that's why they carved out the special exception of rape as well.
In that situation, in the case of a sexual battery, there would be a physical injury that would require medical treatment that could then later manifest in psychological injuries, right?
That's certainly possible.
Right. I mean, so.
Well, I don't think that's possible. I don't think you would ever get a doctor to say that this injury that you suffered from the sexual assault results in this later need for psychological treatment. Clearly, the act that happened to you, I mean, that requires, it's not the injury that results. I mean, this woman could have fallen in the office and hit her neck on a chair and suffered the same injury, easily.
Well,
Your Honor, we wouldn't be talking about this.
I believe it all goes back to the work comp statute was not meant to make a person whole. It was meant to be an exchange of getting authorization of medical care and indemnity benefits immediately through an administrative process and limiting the employer's exposure. And this is one of the areas where the employer's exposure is limited, and that particular situation is excluded.
And Byrd covers the sexual battery scenario.
Correct. Yes. Thank you.
Thank you. Mr. Weiner, I'll give you a little bit extra time.
Thank you, Your Honor. It's our position that Byrd doesn't exclusively cover the rape issue, but there are other issues as well. And, Your Honor, I think you fully apprehended them. There's the issue of the gunshot that occurs in the workplace. I had a case in which a person was shot in the face. That injury healed within the matter of months. Again, the psychiatric injuries that flowed from that simultaneous physical injury persisted for years. Same thing.
There's no problem under the manifestation.
It's not a manifestation.
But it's not a apologize.
That's all right. There's no the gunshot to the face is the physical injury.
Right.
The depression or the anxiety manifests from that physical injury, does it not?
Really, it doesn't, because the physical injury heals. It leaves you, in the case of that gunshot wound, with no residuals, just as Judge Hawks.
But the statute doesn't say, does it, that the physical injury has to continue to afflict the claimant?
That is the manner in which the lower court and the appellees have asserted that the statute should be construed, and that is the exact error that we can submit to the court that the lower court made in reaching the conclusion that it made. Counsel for the appellees.
I understand you're arguing that the sentence, the compensable physical injury must be and remain a major contributing cause, and the compensable physical injury is determined by reasonable medical certainty must be at least 50%. Well, the second part of that clause does not cause your opponent's argument to fail. It simply says shall remain 50%. The gunshot wound in the face, the physical pain, the catastrophic event can cause the anxiety. But I guess the clause that may be problematic is the physical injury must be and remain the major contributing cause of the physical or mental. But I don't read that to be anything, other than the foundation of the manifestation.
And that's my argument. The foundation for the manifestation being that trauma in this case, or being the rape, or being the gunshot wound. Again, those physical injuries may heal, but the physical...
That seems to be a case of... I'm sorry. Never mind.
Okay. I did want to address the issue, because counsel brought up the purpose of workers' comp. And if we consider all this in a broader sense, I mean, really, for over 50 years, the Florida Supreme Court has told us the overall purpose of workers' compensation is to be able to provide a direct and inexpensive method of relieving society of the burden for caring for injured workers, and to place the burden on the industry who creates the condition. And clearly, this is a condition that flowed as a result of her employment. It arose out of her employment. Her accident, and to a certain degree, the physical injuries from her accident, were the major contributing cause of the psychiatric condition and the need for medicine.
I think that's where you're wrong. I mean, I think you could make the argument that she suffered physical injuries, and at the same time she suffered mental injuries. And the question is, does the statute compensate her for her mental injuries if they occur at the same time as a physical injury? And the answer is, as Judge Thomas has said, yes, if it requires medical treatment. I don't think there's any doubt here that she required medical treatment. But manifestation is something that results from the injury and has to result from the injury. I mean, you know, and this is not the case. I mean, if she had fallen at work, like I said, and hit her neck on the back of a chair and suffered the same contusion to her larynx, you know, I doubt she could successfully pursue a PTSD claim. I don't want to go too far with that. Maybe she could. But I mean, it would certainly be a different case than here, where she's saying, look, I got punched in the throat. I'm afraid of that individual. I have all these other issues in my life also. And that was an injury I suffered at the same time. It was a separate injury. I don't know why we're avoiding the reality that you can have a mental injury. And because I think the legislature clearly recognized you can have a mental injury.
Well, in our claim, Your Honor, I agree with Your Honor. Our claim was under Section 440.093 for compensability. The lower court failed to consider that. It was not something that was either addressed by appellees. But I would agree with Your Honor with that interpretation of the statute.
I realize my position is a great mystery here. But I mean, what would be the remedy if my position were adopted? Is it remanded to the JCC to
for findings consistent with interpretation?
You didn't waive that in your. I mean, you pled under 440.093.
I believe it's clear. Yes, I believe that the record would demonstrate that it was something that was the issue of compensability was raised under that statutory provision or 440.093. Yes, I do want to address just one more point. The issue was with regard to clear and convincing evidence. It's the appellant's position that standard, that onerous burden of proof, does not apply to the standard of causation. It only applies to the identification and diagnosis of the injury, and that's supported by the McKenzie case. I heard Your Honor reference the clear and convincing, and I wanted to sort of illustrate. And again, I realize I'm over my time, and I thank the Court for the opportunity unless there's any other questions.
Thank you.
Okay. Thank you.